adjudicates your applications. So thank you all for being here. We are a couple of minutes late, but today I wanted to talk about how USCIS adjudicates applications, some of the latest trends and things to watch out for in 2026. So a lot of the things I'm going to talk about has to do with the source of funds documentation, because when it comes to project documents, you can look at for projects that have already been pre-approved. So on the project side, if you're investing in a regional center, you can either choose to select projects that have already submitted their application to USCIS and received an approval. However, if there is a project that you really like, financially or what they offer, and they still have not received an approval from USCIS, you may look to the history of this regional center. More experienced regional centers are extremely highly likely to have project approvals. So if that's the risk you are comfortable taking, you may still pursue that application, but obviously project-related approval risks can be fully eliminated if you choose to go into the project after they already received approval from USCIS. So I wanted to focus today's live on really the source of funds, right? So there are two things that USCIS looks at when they're adjudicating your petition. Number one, project and whether or not the project complies with the requirements. And number two are your individual source of funds documents. So were your funds earned lawfully? Were they transferred lawfully before they were committed to the project? So we have had some pretty big changes in 2026, and I want to draw your attention to them. So number one, the regulations do state that an investor should provide 7 years of tax returns with their petition, whether or not it's relevant to your source of funds. So I'll give you an example. Maybe the money you're investing, you earned 10 years ago, right? You earn that money, you pay tax on it, and you've been keeping it in a savings account for 10 years. Today, you pull that money out, you invest. You will have to source that income from 10 years ago, right? And show those tax returns. Whether or not you made any money in the last 7 years, in theory, is not relevant to your source of funds documentation because you're not using the earnings from the last 7 years for your petition. But even though it's not relevant, the regulations state that every petitioner needs to provide 7 years of their tax returns. In the prior years, we have consistently seen that USCIS didn't enforce this rule strictly. So if the 7 years of tax returns was not relevant to your source of funds, even if you didn't provide it, they either didn't ask for it or maybe they would send a request for those documents. Today, what we're seeing is even if it's not relevant to the money you're investing, they're applying this rule very strictly. So not submitting your 7 years of tax returns can be a grounds for immediate denial without even an opportunity to supplement the record. So they don't have to send you a request for evidence first. They can just issue a denial. So this is definitely a big change that we haven't seen before. Another thing that we're seeing, say you were not subject to any income tax returns. Maybe you were living in an area where there is no income tax, such as Dubai. Maybe you were a student and you don't have any income, so you don't have to report it. USCIS actually wants to receive a proactive statement from you explaining that you had no tax returns in the last 7 years, or providing only the relevant years and proactively explaining and issuing a sworn statement that you did not have any tax returns to turn in. So simply sending your petitions without saying anything and not submitting the 7 years of tax returns can be grounds for immediate denial. I'm not going to tell you that that's legally correct, but that is what we're seeing currently in the adjudication. Some other things. And so, of course, full disclaimer, nothing I'm saying in this YouTube live is giving anybody any personal advice. I'm just sharing the latest trends and adjudications and the law And anything that you do before you file any petition or before you make any arrangements, you absolutely should be speaking to your own immigration attorney and seeking advice pertaining to your set of facts. All right. And give me just 1 second because I do want to adjust the lighting. For some reason, I don't have enough light. And so we're going to move some light to be just a little closer. All right. So 7 years of tax returns, strictly required. Now, often we get asked, like, how often do we have to go back in the source of funds? There is no time limit. So if your original funds derived from 30 years ago, so say your grandparents sold a business and bought land with it and then gifted you that land, USCIS will ask for those documents or some sort of evidence from 30 years ago indicating that the land was purchased with lawful funds. Understandably, not everything can be derived from 30 years ago, so they may not ask for bank statements because they most likely will not exist and not be anywhere in the archives. But they may ask for property records, business records, maybe articles, or some sort of other direct and indirect evidence substantiating the claim. What other adjudication trends we're seeing? We are seeing a lot of questioning of third-party loans. You can borrow money from the bank, so home equity lines of credit are very common. They're commonly utilized in EB-5, and you can borrow from a bank, especially if it's against your property. You will have to show the source of funds with which you purchased the property. But some of the latest sort of challenges that we're seeing is if the money is borrowed not from a banking institution. So, for example, you borrowed it from a friend's company, you borrowed it from an individual. In that case, USCIS wants to see the full set of source of funds documents for this lender if it's not a banking institution. And you may think, what's considered a banking institution? What if I borrowed the money from a lending institution that's not a bank? Interestingly, I did see recently USCIS question when a gentleman took a loan from a huge lending institution, company literally in business of providing loans, but they're technically not a bank. So in that case, he was able to show that that company is publicly traded. Their tax information is available online. However, this was definitely something that they questioned. And so make sure that this is, a company in line and is properly licensed to provide financial services. If you're borrowing from an individual, if you're borrowing from an individual's company, they need to be prepared to provide tax returns. Okay. What else? Some of the latest adjudication trends. This is not really new, but it's worth reminding. If you're transferring money from one country to another, any transfer service that you're using, currency exchange, transfer companies, they have to be licensed, and you need to include their license in the petition. They have to be licensed to operate and do these sort of currency swaps. And what else are we seeing? We are seeing some adjudication where partial investments were made. And this is a big one. There are a lot of people in the US who heard that a partial investment is something that an EB-5 investor can do. So instead of investing the full $800,000 minimum investment amount, they can invest part of that, file their petition, and then invest the rest later. Now, I personally never like to do this route because it does create additional immigration risk. Number one, although the law does say that an investor can be fully invested or be in the process of investing at the time you file your petition, so presumably partial investment is allowed, the law also says that the investor has to be eligible, fully eligible at the time they're filing the petition. It's a little tricky to say if you haven't fully invested the funds, how can you be fully eligible? Because to be eligible, you have to source the funds. So what USCIS has interpreted is they said, if you're making a partial investment, that can be okay as long as you still provide all the full source of documentation for the money you will use in the future to pay down the rest of the investment amount. I'll give you an example. Say I have half of my savings are in a CD. The term of the CD doesn't expire for 6 months. If I pull the money out now, I will be subject to a penalty and I will lose my interest. If I wait 6 months, I get my full amount plus interest. So I may choose to do a partial investment today, file my petition. In 6 months, when the CD comes to term, I will invest the rest. I already know where the money is coming from for the future investment, and I can fully source and trace it in the original petition. I can trace where that money came from, how I earned it, and how it got to the CD. But the latest adjudication trend that we're seeing on partial investments is USCIS started denying cases without issuing RFEs or even NOIDs, just straight out denial in cases where the investor has made a partial investment, and at the time the adjudicator picks up the petition to review it, the rest of the investment has not been made, or it was made, but that information was not supplemented to the petition, right? So we are seeing a string of those denials. Again, if you can avoid partial investments, I think that's a prudent thing to do. If you cannot avoid partial investments, I would recommend only to do them for a short period of time. So maybe no more than 3 or 4 months, because some rule petitions have been reviewed as quickly as 3 to 4 months. And USCIS is taking the approach that at the time of the review of the petition, your funds have to be fully in, which is very difficult to predict, right? Some petitions take a year to be adjudicated, some petitions take only a few months. So that would be another thing. Also, if your agreement with the regional centers for a specific set of dates, you want to have your investment in by those dates and immediately supplement your petition with USCIS that you have invested in and supplied that. So they are basically coming down harder on partial investments. So two big changes that, to summarize, is the 7-year tax return requirement is now a hard rule, whether it relates to your source of funds or not. USCIS is enforcing that very strictly. And partial investments, USCIS is interpreting it as the fact that the full investment has to be in at the time they adjudicate your petition. I can't say that that's perfectly viable in the law. I personally haven't really found justification for that interpretation in the law, but that is how USCIS attorneys are currently interpreting the partial investment law, that the full investment has to be made at the time the petition is reviewed. So let me think, what else? Retirement funds can sometimes be utilized without pulling your money out of retirement, as long as it's in the same name, the investor name and the retirement funds are the same, and the project is structured to accept them as such. Another big thing is third-party lenders. If you're borrowing money and taking an unsecured loan, and this lender is willing to give you the money towards a specific project, USCIS has taken the approach that that lender should in no way, shape, or form be affiliated with the project that's receiving the loan, right? So essentially, they're trying to avoid a model where the regional center is actually giving you the money, charging you an interest, and is taking that money back to finance their own project. So kind of things to keep in mind there. The whole third-party loan market right now in EB5, it's hard to find lenders that are still willing to loan towards EB5, just because we have seen some denials last year, and USCIS is still interpreting how they're going to treat those models, right? Everything else, sort of as usual, the funds that you have earned have to be sourced, traced. USCIS really wants to see that people who are applying for EB-5 are tax compliant individuals, and that's why they're asking for tax returns. Generally speaking, it seems like as we're going into 2026, we're noticing that the adjudication is pretty quick, especially for rural projects, but they're stricter on how they want to enforce the source of funds rules. So to kind of cover your typical sources of funds, obviously it can be your salary, it can be your income from the business, it just has to be your income. So dividends, distributions, you can borrow. So if you're a shareholder in a company and the company has undistributed profits, you are allowed to borrow from your own company as long as it's a legitimate loan in the jurisdiction where you're taking it out. So there are a lot of individuals that own their own company, they take a shareholder's loan from their company. Of course, in that case, you will need to provide full company financials to show that they're engaged in a lawful activity and they have the financials to actually give you the loan. Gifts, very common. Gifts do not have to be gifted by a relative, so there's no requirement that the gift comes from a relative. It could be friends, it could be family. Gifts are a very common way to finance EB-5. Loans, you can take an unsecured loan. So the Zhang decision still stands, which states that proceeds of a loan are considered cash for EB-5 investment. An individual is allowed to take out a loan. They don't have to secure it with personal assets as long as it's not secured by assets of the project. They can take out a personal loan and use the proceeds of the loan to invest in EB-5. So a lot of people borrow money from their friends, from their family. Just to reiterate, if you are borrowing from a non-banking institution, the lender, the person who's giving you the money, still has to show their full source of income. So how they accumulated this money and how they earned it. So you want to make sure that they're going to be willing and able to provide those documents. Of course, inheritance. Always be careful when you're looking at inheritance, because when you're dealing with inheritance, make sure this was not an inter vivos gift, because there's a difference. Did you receive the money while the person was still alive, or did you receive it after their death? In my personal opinion, I think if it was pure inheritance and you received the money after the person was deceased, it's like a true inheritance. There tends to be less questioning because A, the person who gave the money has already passed away. B, it doesn't seem like these funds were planned and transferred intentionally towards EB-5 to bypass some sort of source of funds requirements. And generally it answers, in my opinion, it answers the question of how did you derive it? If you derived it through lawful inheritance, the prior origin of the funds might be less relevant. However, I have seen USCIS ask for documents showing the source of funds of the deceased person. Obviously, those are usually not perfect, but you want to have some evidence to substantiate that this deceased person was engaged in lawful activity and the funds that passed on through inheritance were lawfully earned. Another, coming back to inheritance, if it was inter vivos, meaning the person who gave you the money, maybe it was grandparents, maybe uncle and aunt, or you received it some sort of as a trust. People call it inheritance because it's something they were sort of entitled to. But if it passed from individuals who are still alive, then USCIS is going to treat it as a gift, and they absolutely will want to see the source of funds of the giftor or whoever put this money in the trust for you to receive it. So those are kind of the basic things on how to source your funds, what latest adjudication we're seeing, and what to look out for. The way also the processing happens is when you pick a project, you want to make sure this project has already filed the project documents in a 956F petition. Once that happens, 10 days later, you can file your petition, 10 or 11. But they will provide, the project has to provide you a receipt notice for the I-956F. And of course, in order to reduce immigration-related risks, you may want to choose to go with projects that not only filed their 956F petition, but have already been reviewed and approved. If that's an option, it eliminates a lot of the initial risks of the possibility of the project not being approved. So if it's a gift, we have a question. If it's a gift, you don't have to pay taxes here in the States. So it's a good question about gifts. So the United States does not tax the person receiving a gift. They levy the tax on the giftor. So if the giftor is not a U.S. citizen or resident, is not a tax resident, then the United States doesn't get involved in, like, there's no tax on the U.S. side. If the giftor is a U.S. person, U.S. tax resident, this gift will go against their lifetime tax-free gifting. So there's a certain amount of $1 million. I honestly don't know what that amount is. You guys will have to Google it because they change it. And that's a question for a CPA. But if the gift is coming from a U.S. person, every U.S. person has a lifetime amount of money that they can transfer as a gift and not be subject to tax. I don't remember what the amount is today. I believe it's around $5 or $7 million. So if they're gifting $800,000, it goes against the grand total. Say you're dealing with a person who has already paid, maybe they already over their lifetime gave away $10 million. Now they're giving you $800,000. There maybe is going to be a gift tax that is levied upon them, and they need to pay. If the person is not a U.S. person at all, you have to check the local country. There are some countries that tax gifts. So even if the person who's receiving the gift is not a resident of that country, they still tax the giftor. So that's something you want to check with the appropriate tax attorneys of the country where your client is receiving the gift from. So you want to make sure that they're compliant. Okay. Yeah. So yes, in the comments, yeah, we see like the lifetime, the overall lifetime tax-free gift amount has been changing. I believe the old one was like 17 million, and they're now trying to reduce it, but it used to be a substantial amount. Again, this is tax questions are better asked for a CPA. I'm not a CPA. I'm not a tax lawyer. I can just point you like issue spot and tell you, okay, this is who you should check on this. But I know, generally speaking, for the majority of people, when they're receiving a gift in the U.S. and the person who's granting the money is in the U.S., for most of them, there's not going to be a gift tax. So gifts are common. Loans are also common, but this is something that not a lot of people talk about. The U.S. immigration requirements, the EB-5 program, wants your source of funds to be lawful, and they care about your source of funds requirement. You can receive it as a gift. You can receive your money as a loan. So say my aunt wants to help me out, but she doesn't want to gift me the money. She wants to lend me the money, so I have to repay her later, either when the project repays or out of my future earnings. Say I'm a 25-year-old student. I just finished grad school in the US. I don't really have any assets to my own name. So my aunt wants to lend me the money. The big question becomes, can I do the EB-5 program? From the immigration standpoint and the EB-5 program rules, absolutely. I'm getting the funds lawfully as long as my aunt is willing to show that she earned them lawfully. I can use the proceeds of this investment and invest in a project. But there's a second set of laws, which are the investment laws. So we have the Securities Exchange Commission that regulates investment activity in the US. And they have their own rules. Most EB-5 projects are structured under the SEC rules as private placements, What that means is they're not registering these investments. These are not public offerings. These are private offerings. And private offerings have restrictions. And many private offerings are restricted so that they can only accept what's called accredited investors. So the immigration and B5 rules don't require the investor to be accredited. Anyone can utilize the EB5 program, accredited or unaccredited individuals. But the investment rules for the majority of projects, not all, but for the majority of them, require that all the investors that go into this project are accredited. What that means is the investor has to have either a net worth of over $1 million, not counting their primary residence, an income of either $200,000 annually, or as a married couple, you can have income of $300,000 annually. And a third way is if you can show that you're a licensed financial professional, so like certain FINRA licenses make you an accredited investor. For example, I'm a licensed, in real life, I'm a licensed FINRA licensed broker, so I'm considered accredited. I can pursue different investment opportunities and I go in as an accredited investor. So these two requirements are often confused in EB5. They're not the same. They are not immigration requirements. So immigration doesn't need $1 million of assets from the individual. The immigration requirement is that you have to show a lawful source of funds. It can come from a loan, can come from a gift. But to meet the SEC project-specific investment requirements, for certain projects, you can only go in if you're an accredited investor. And if an individual is receiving a loan, so coming back to our story, I'm 25, I don't have any assets of my own. Even if my aunt is willing to lend me the money, I'm not accredited. So I will have a really hard time finding an EB5 project who can accept me, because most of them can only take accredited investors. If my aunt, on the other hand, gifts me the money, so say she gifts me $900,000, I have about $100,000 of my own money, all of a sudden I'm accredited. As an accredited investor, I can look at an EB5 private placement offering. So those are two separate requirements, also kind of to keep in mind. All right, so if we don't have any more questions, we are going to